Okay, this is an introduction to legal research, and before you get too frightened, we're really just going to skim the surface of legal research. We're not going to get too geeky into it, but I just want to sort of give you an overview so that you, A, understand how the law is organized, how it's written down, and how it's accessible, and also how you go about finding a particular piece of law if you happen to be looking for it. So, we're not going to go too deep into it, but we're just going to kind of give you a basic primer. And I want to say that for this presentation, especially when we get into the later part of this presentation, we're sort of assuming that the internet doesn't exist. So we're going to pretend that we're going to dial the clock back like 25 years, and when we're first talking about all this stuff, we're going to assume that the internet doesn't exist and assume that the the only place you can get all of this stuff is in books. And there's a reason that I'm doing that, and the reason is that even though today a lot of what I'm going to show you in this presentation, at least in the late part of the presentation, you can do online, the organizational structure is still set up as if there were books. So, in other words, the way that legal research is organized is it's organized according to books and volumes and, actual physical pieces of paper. Now, I want to revisit this idea that I mentioned very early in the semester, this idea of the fabric of law. And the reason we refer to it as a fabric of law is because it's a bunch of different threads coming from a lot of different places. So, for example, every day, all of us, when we get up in the morning and go through our day and do the various things we do, we are all affected by laws. We probably don't think about them that often, but they're there. And they basically tell us things that we're allowed to do, things that we're not allowed to do, that sort of thing. And they all come from various different kinds of places. So, for example, the Constitution, common law, which comes from various court decisions, statutory law that comes from Congress, administrative law that comes from administrative agencies, executive law from the president, treaties. And so we've got all these different sorts of things that, affect our lives, and they're sort of in this kind of vague fabric that we really don't think about too much. Also, we've got laws that are coming at us from the federal level. We've got laws that come at us from the state level. We've got laws that come at us from the local level. So we've got all this different kind of stuff going on. And the idea of legal research is, we need to be able to find this stuff specifically if we need to. So, for example, if I get into some sort of trouble or I get into a dispute with my neighbor, I want to be able to find out, well, what does the law actually say about this? And this is sort of gets to the core of what legal research is. So, in order to make all this possible, the law leaves a paper trail. In other words, the law leaves a record. And as I said, the reason for this is we need to be able to figure out what has been decided before, what laws have been passed before. This idea of precedent. And remember, precedent is essentially when a court decides something the same way as a previous court decided it. In order to do that, the current court needs to be able to find out, well, okay, what did the previous court or court say about this? So, we need to have this paper trail. We need to have a way of finding out what has been passed before. We also need to know how do our current decisions and laws fit into that history of laws. So if Congress passes something today, about health care or about gun control or something like that, we need to be able to know, okay, how does what they decided today fit into what's already out there? As another example, we need to be able to find out, for example, if we get our hands on a court case from 1945, we need to be able to find out, well, okay, is this still valid? So, in other words, is what the court said in 1945 in this case, is this still valid? Is this still the way things stand today? And I point out here, as I said in the first slide, increasingly this paper trail is actually a digital trail, but the paper organization is still important, and you'll find out why that is coming up. But bottom line, the paper leaves a law trail. The law leaves a paper trail so that we can find previous decisions and also hopefully find, where previous decisions fit into the law as it stands today. Okay, so one of the first things that you need to get a grip on is the idea of reporters and digests. And just to kind of keep things simple here at the beginning, let's assume that we're talking about court decisions. So once again, if you think back to early in the semester, and we've kind of been talking about various kinds of common law cases, what's happening is you've got literally hundreds, thousands of courts that every day are making decisions. And, let's take the Supreme Court, for example. Like, they might on a given day make a decision about abortion, and then a decision about gun control, and then a decision about money. And they make those decisions, on a given day. So, because that's the way courts work. I mean, courts, essentially don't get to say, hey, let's hear all the cases about this on this day, and we'll hear all the cases about this on another day. No, they basically take cases as they come to them. And so a reporter is going to be a way of organizing those decisions that is chronologically based. So once again, the Supreme Court comes out on a given day, and it releases its decision about abortion, and then it releases its decision about gun control, and then it releases its decision about money. And so in a Supreme Court reporter, we would see those three decisions chronologically. Okay? Basically, the order that the court made them in. Now, that is well and good, but it really doesn't help us that much if we're trying to figure out, something by topic, because we don't want to have to weed through like all of these different kinds of, various decisions about various things if all we really care about is gun control. So that's where a digest comes in. A digest organizes various decisions by topic. So essentially what happens is at some point after the Supreme Court makes its decision about abortion, let's say, somebody's going to go through and basically fit that new decision into the existing decisions that are already out there, and they're going to do that in a digest. So bottom line, a reporter is organized chronologically. A digest is organized by topic. So as a way of maybe getting a grip on this, your textbook is essentially what? I'm going to let you think about that for a second. Is it a reporter or is it a digest? Well, you should have answered digest, because essentially what your book is it's got various chapters about various kinds of things, but it's organized by topic. So that's sort of one way to think about it. The other way to think about it, I don't know if this metaphor is exactly good, but I thought of it and I'll share it with you, is it's like if you worked in a brick factory and like every day you're basically like just turning out individual bricks. Okay, and so you have this brick and then this other brick, and they load them on trucks and they take them away. So you're kind of the reporter because you're just sort of making these bricks in order, whatever. As I talk about the metaphor, I'm not liking it as much. But so you make the bricks and then they go away somewhere and then somebody puts them together into a house. So that idea of kind of putting them together into a house is sort of like the digest. Okay? But bottom line is reporters are chronological, digests are by topic. Now, the other thing is reporters usually are, and we're talking about books here, reporters are usually going to be one court system or one agency or one government body, whereas digests are often going to combine multiple courts or multiple different sources of laws. For example, there is a series of books called U.S. Reports, which is where the Supreme Court decisions are listed chronologically. Okay, and so again, that's only the Supreme Court. But then when we go to look at a digest, like our book, for example, our book contains Supreme Court decisions and also various federal court decisions and even state and local court decisions. So that's reporters and digests. And so I mentioned that reporters are generally speaking going to have just one court or one series of courts in them. And this slide shows us our essential examples of what the reporters are for the federal court system. So the Supreme Court, we will find it in a series of books called U.S. Reports, which is abbreviated U.S. That abbreviation will become a little bit more important to you here coming up. Our circuit or appeals courts are found in the Federal Reporter, which is abbreviated F, F second edition, or F third edition. And then our district or trial courts are reported in what is called the Federal Supplement, which is abbreviated F Sup or F Sup second edition. And once again, if you were to go to the library, pick up one of these volumes and open it up, you would basically see court decisions in chronological order. So again, you open up the book, and this case might be about royalties to book publishers. You page through, and the next case might be about gas wells, and then the third case might be about privacy. So it's chronological, not organized according to topic. The other thing to understand about reporters is reporters are essentially where we're going to find the entire court case. And once again, let's use our textbook as an example. We already talked about our textbook as being a digest. So, for example, New York Times versus Sullivan, a big case we've talked about. In your book, it is just, a few paragraphs about New York Times versus Sullivan. And it refers to the actual court decision. So if we wanted to actually read the entire court decision on New York Times versus Sullivan, we would actually go to the Supreme Court, the U.S. Reports. Then that would show us the entire case of essentially every single word that the Supreme Court said about New York Times versus Sullivan. So the reason that reporters are important is because that's where we're going to find the case in its entirety. In a digest, we're probably just going to have sort of a summary of the case, which, again, might be good. That might be all we need. But if we really want to see, exactly what did the court say and what was everything they said, we need to go to the reporter. And then when we talk about, for example, federal statutory law, which comes from Congress, our reporter there is what's called statutes at large, which is abbreviated STAT. And the digest is what is called U.S. Code, which is abbreviated USC or USCA. And, I have reporter and digest in quotation marks because there are some purists who would say, well, they're not actually reporters or digests. But for our purposes, we can say that. And, once again, what happens is, Congress, they haven't been passing much lately. But, theoretically, they're passing a lot of laws every day. And the first law they pass might deal with the Keystone Pipeline. The second law might be about repealing Obamacare. So, these decisions, these things that Congress passes would be reported chronologically in statutes at large. Then, when something does actually get passed, the digest actually fits it into the existing law. So, if Congress did pass a law about, let's say, copyright, that would, appear in statutes at large, but then eventually it would be fit into the U.S. Code. Because whatever they changed about copyright, somebody would have to go in there and basically modify the existing law so that it would reflect that new court decision or that new thing that Congress passed. Same kind of thing when we talk about administrative law. The Reporter is the Federal Register, which is literally a book that comes out every day that reports the various decisions of federal administrative agencies, but those are in chronological order. And then the Digest is the Code of Federal Regulations, which is abbreviated CFR, and that would be the series of books that organizes all of these administrative laws according to topic. So if we wanted to see, like, what are the FAA laws about air travel, we could look in a particular volume. If we wanted to see what are the FCC laws about running an AM radio station, we could look in a particular book of the Code of Federal Regulations. So, again, all of the law sort of uses this model of reporters, which are chronological, and then digests, which are by topic. Okay, and I just want to point out that there is an area in the library where you can find a lot of these books that I'm talking about. They kind of keep moving it around a little bit, but the library does have a government documents collection where you can find a lot of these reporters and digests that I am talking about. All right, kids, this is getting to the meat of the discussion. What you see on your slide right now is what is called a citation. And citations are what we use to find the law. So a citation is going to be extremely important to us when we are looking to find a particular court case or find a particular part of the law. And citations are expressed in a particular way, and we have to follow those particular guidelines so that our citations are correct. And so what I'm going to do here is go over the various parts of this citation and talk about what they mean. And this particular citation, this is one that you actually would find in one of the footnotes in your book. This is a case that we actually didn't talk about. I might have mentioned it in passing, but it was a case where a newspaper printed something bad about a guy, and then he wanted to have a right of reply on the front page. He wanted to write his own article, basically rebutting the previous article. The paper said, no, you can write a letter to the editor and we'll print that, but we're not going to give you the front page. It eventually reached the Supreme Court, and the Supreme Court said the newspaper was within its right to deny that person a right to be on the front page of the paper. So this is a Supreme Court decision, Miami Herald versus Tornillo. Okay, the first part of the citation is the name of the case. In this particular case, Miami Herald Publishing Company versus Tornillo. So we have the name of the case and the party initiating the case, and remember, this is going to be the plaintiff or the appellant is going to be listed first. So the party that essentially requested this case is going to be listed first. So again, in a trial court, that is going to be the plaintiff, and in an appeals court, that's going to be the appellant. Now, this is a court decision citation, but if we had a citation to, for example, statutory law, the name of the law would be what appears here. So, for example, Obamacare, the official name of Obamacare is, I believe, the Affordable Care Act. It's got more to it than that, but if this were that, instead of Miami Herald versus Tornillo, it would say, Affordable Care Act of 2009 or whatever the official name is. So that's the name of the case. The book series tells us which reporter or digest we are going to find this case in. And this comes back to those abbreviations. U.S., as you might know from the previous slide, means that we're going to find this particular case in U.S. reports. So this is telling us that the book series that we're going to find this in is U.S. reports. Once we find the series of U.S. reports, the number in front of that tells us the volume number. And U.S. reports, as I've mentioned, is going to be a series of books. They're going to be piled up on a wall and a shelf in the library. And this is telling us that I want to look for volume number 418. And now this tells us the starting page number. So after the book series, that number is going to be the starting page number. So if I go to U.S. Reports, pull out volume number 418, and turn to page 241, I will find Miami Herald Publishing Company versus Tornillo. And then finally, we have the date, which isn't exactly important to us in finding this case, but does sort of just give us context for when the case was decided. Now, I want to point out, too, that this is a Supreme Court decision, and it's in U.S. Reports, and I've already mentioned that U.S. Reports only includes Supreme Court decisions. So we know automatically that this is a Supreme Court case, because those are the only kinds of cases that get reported in U.S. Reports. However, here is a case that is not a Supreme Court case. This is a case that is the Federal Reporter. You can see Federal Second Edition. And we know from the previous slide that these are appeals courts. And the thing that we add to the citation for these kind of cases is next to the date, we put an abbreviation for which court decided this. And in this particular case, this was decided by the Second Circuit Court in 1940. So, you know, when we have a court decision that's coming from somewhere other than the Supreme Court, part of the date is also going to include an abbreviation for what court decided that case. Okay, so let's try an example of how we might use a couple of different types of legal research. Let's say our first example, we know a topic, but we don't know anything else. And I essentially want to find out, well, what is the law about that topic? And let's just say, for example, I want to know, in the state of Ohio, is it libelous to call a woman a whore? That's what I want to know the answer to. So, having, a citation or something really isn't going to help me with that. I essentially need to look this up by topic. So what I'm going to want to do is start with a digest. And this example that I'm showing here is Ohio Jurisprudence. This is a series of books that used to be in the library. I don't think we actually have this particular series of books in the library anymore, but it is available digitally, which I'll talk about. But what Ohio Jurisprudence is a digest of essentially all of the common law court decisions in Ohio. And you'll see there's a whole series of volumes there, and if you look real closely, you'll see on the spines of the book, it's alphabetical by topic, so you can see that volume 40 is Energy to Enforcement and Execution of Judgments. And so essentially this is Ohio common law organized in the form of a extended digest. Okay, so going alphabetically, I find the volume that includes defamation and privacy, and there you can see it. And then I open up that book, and I find the section about defamation and privacy, which begins right here. And then if I read through this a little bit, you'll see that I reach a point where I have a basic definition of libel, which begins right here, and you can see that text looks pretty similar to what we talked about when we talked about our definition of libel. And here I'm just showing you an example of a citation used in this digest. And this particular citation refers to a case of Gosden versus Lewis. And you can see that it's got a citation there, which Ohio Appeals 3rd edition is another reporter. And what I would do to find that case is find volume 116 and then look at page 195. And so what I'm showing you here is just this idea of how we use citations to basically refer from a digest to the original court case. So this digest here is probably just giving me like 1 or 2 lines about Gosden versus Lewis. And if I actually wanted to look up Gosden versus Lewis and see everything that the court said about that, this is giving me the citation to do that. Okay, and then eventually, if I keep looking, I find a section, Charges Against Women. And you can see here that it gives me an overview, and it says, words uttered in the presence and hearing of others, imputing to a married or single woman a want of chastity are in themselves actionable. And then you can see, and I apologize for my photography here, but I'm going from one page to the next. you can see that when we get to the second page, it says it is actionable per se to call a woman a whore. So that's the answer to my question. So it is potentially libelous for me to call a woman a whore in the state of Ohio. And once again, if I wanted to actually use those footnotes that you can see listed there, I could actually then look up the particular cases and get more detail about that if I wanted to. But this is a basic example of using a digest to find an answer to a question. And if I wanted to go much deeper into that question, then what I could do is use the citations in this digest to actually go to the reporter and look up more detail about the cases. All right, let's try another different type of legal research example. Let's say that I now have a citation and I want to find this case. So this is the Cox Broadcasting versus Cone case, which you'll remember we talked about. This was the case that involved naming rape victims, where the Supreme Court ultimately decided that you couldn't punish the media for publishing something that was part of the public record. And so I have here my citation, Cox Broadcasting Corporation versus Cone, 420 U.S. 469 from 1975. And again, I don't care that much about the date as far as finding it, but it's nice to have the context. So the first thing I know is that I need to find the U.S. reports. So I search around or I ask a librarian, and eventually I find the U.S. reports stacked on shelf after shelf in a dusty, dark back corner of the library. And if we look closely, we will see on the spines of the books there are numbers which indicate the volume numbers. And boom, there it is, volume number 420, which is the volume number I'm looking for Cox versus Cone. And if I open up volume number 420 and turn to page 469, because that is the number that was listed in the citation, well, by God, there is the beginning of Cox Broadcasting versus Cone. So that's a quick example of how you would find a case if you have a citation. So what we're going to do in the upcoming videos and presentations is sort of now take this into the digital realm and talk about how you find a lot of these things in the digital realm. But I do want to once again point out, I didn't just waste your time here by showing you this print stuff, because even though it is in most cases much easier today to do legal research online, digitally, the way things are organized is still by books. And so you're still going to use volume numbers and page numbers, even though, strictly speaking, we don't care about those things as much online. So even though we have a much easier way of researching the law right now with the Internet, the way that it is organized is still based on the previous print model.